Good evening, everybody. Thank you so much for joining us for tonight's webinar. My name is Blair McClanahan, and I am one of the attorneys here at Cheryl David's office. So a little bit about tonight's webinar. It should be about 60 minutes, give or take. And throughout this, we'll be talking about estate planning, asset protection, probate. We do have an option where you guys can use the chat feature if you have any questions throughout this webinar. We'll try to get to them all and save some time at the end for questions. Livia, my wonderful assistant, will be monitoring that and may read me some questions here and there, and I'll try to keep an eye on it too. After tonight's webinar, all of you will have an opportunity to schedule a complimentary personal consultation with one of our attorneys. Throughout, Olivia will be posting a link. So if you go to the chat and click that link, you can schedule right from there and it'll give you all the times that are available. We will also be calling all of the people who attended tonight in the morning. So if tech is not your thing and it is not mine, we'll give you a good old-fashioned phone call tomorrow. Again, everyone is entitled to a free personal consultation with one of our attorneys to discuss your estate plan or anything related to the areas that we practice. And we have a great group tonight. I know one of our attendees is having a watch party with her friends at home. So hello, grab your popcorn, get a good drink, and we'll try to make this as entertaining as we can. One thing I will let you know is that while hopefully you can hear me, and definitely let us know in the chat if you have any technical difficulties or can't hear us or see the video, but we cannot see you, so get comfortable. I'm going to play a little video in a second, and then I'll be back.
I got a dreaded phone call. My sister was in intensive care. We made it up there and she passed away. She had contracted bacterial meningitis. And the thought that I could lose somebody so dear to me so quickly was devastating, and it made me rethink absolutely everything, but especially my career. Realizing that what we went through with my sister was something that happened to people every single day. And I thought if I could be of help when people are going through that horrible time in their life and make it a little bit easier.
My husband, Wiley Harris, passed away in 2017. And then I realized I needed some help. The human aspect means a lot to me. And some places are business, business, business to the end of day. But they have been very conscientious and they have led me into the right direction. She got some great people working with her. I just have full faith and confidence in the staff.
It's very special to me that we help families, but we're also a firm that's comprised of a family. It's myself, it's my daughter Blair, the other attorney that I work with, Justin Plummer. He's like family. The clients respond to this family atmosphere, and I think that they can feel that we really care.
Well, I wanted to ensure that my family would be taken care of.
We also first met Cheryl through his mother, who came basically to live with us after his father passed away, and so we would try to make it simpler when it came time for us to deal with her.
After we met Cheryl, she gave us the ropes and transfer of the estate took a matter of weeks.
No one wants to talk about death, but it's something that's inevitable for each and every one of us. It's smart to come in and have a conversation, because if you don't have a conversation, you're not protecting those that come after you. We recommend that you come see us at the law offices of Cheryl David, and we'll sit down and we'll listen to you. and we'll try to come up with the best plan that we possibly can.
Thank you so much for watching our video. So yes, again, for those people that are on here new, my name is Blair McClanahan. I'm one of the attorneys here at Cheryl David's office. I also have the great honor of being Cheryl's daughter. So it is quite the family business, as you have seen in the video. I handle a few different areas of law here. Pretty much all that our firm does is estate planning, and not pretty much all that our firm does is estate planning. So we handle wills and trusts, which is estate planning, elder law, so protecting assets when people get sick, as well as probate and trust administration after people have passed away. So I assist with all three of those areas. Justin, our attorney, also handles probates as well as estate planning. And Cheryl, my mother, helps with estate planning. So if you decide to schedule an appointment, you'll be put with any one of the three of us. Everybody is so excellent here, so I know that you'll be happy with whatever attorney you're with during your meeting. If you would like to schedule that meeting, for those of you that have signed on more recently, if you go to the chat feature, you can actually click the link that Olivia's provided and go ahead and schedule directly there. For those of you that would prefer, we will give you a phone call tomorrow. We are part of a national group called the American Academy of Estate Planning Attorneys. And why this is relevant to you all, while I practice in North Carolina, all states have different laws. So you may have family members that live in other states. Occasionally we have people that attend this webinar that are not North Carolina residents. And if so, you can actually go to the American Academy of Estate Planning website and find an attorney who practices in pretty much every state in the country. So we are so honored to be part of that group. We stay abreast of all of the current topics, and there have been some recent law changes that we'll talk about tonight. So a few ground rules for tonight's webinar. If you have any questions, please feel free to use that chat feature. If you want to jot down comments, it is public, so I would leave any personal information off of that. We also have a Q&A icon. Hopefully you can see those icons. If not, and you don't feel comfortable listing your questions here tonight, let's schedule a free consultation with one of our attorneys using that link Olivia posted earlier, and we'll be happy to talk with you. We do request that appointment be made within the next 2 weeks, and all decision makers be present. So that means if you are married and you and your spouse make decisions together, you have joint accounts, we would like that your spouse be in that meeting as well. Or if you know, I couldn't possibly move forward without my children being involved, you are more than welcome to have your children on that appointment as well. Feel free to stay in touch with us. We can add you to our newsletter. If you send Olivia a message, we have an amazing newsletter that goes out a couple times a month with just relevant law changes and interesting articles. We also have free reports and articles on our website as well, if you want to check those out. So congratulations, by coming here tonight, you have braved some of life's hardest topics. What we see with poor estate planning is families very often torn apart, because if your wishes are not set in stone, it's up to your beneficiaries or your children or family to sometimes guess what would have needed to happen, who gets what. And if you don't have a plan, the state of North Carolina has one for you, and it's called intestacy. And not everything goes to your spouse. So especially if you're married, it's so important to have estate planning. And even if you're not married, it's even more important to have estate planning. But we want to make sure to be very intentional with our plan, because the more intentional and concrete we are now, the less fighting hopefully there is later on down the road. We've often seen that a lot of people come in with plans that may not work. They might have plans that came off the internet. And while those are cheap, I can't argue that, they are not very state specific, and they are very one size fits all. And what I've seen in my time handling probates, a lot of times those plans do not work, or people make changes on their own and they do not always work. We'll discuss death and taxes tonight, as well as nursing home expenses and how to protect your estate in the event of illness. We often find here that there are 3 reasons that most families don't plan. Number 1, procrastination. There's always tomorrow. Let's put it off. Death and planning. This is not a fun topic for everybody. For some people, maybe it is, but this is just oftentimes not something that people want to talk about, even if it is top of mind. So congratulations for coming. This shows that, you're not procrastinating this. Number 2, lack of knowledge. So there's always continuous changes in the law. You don't know what you don't know, and nobody wants to be made a fool of. So what we often see is people keep pushing it on. We'll wait till the next election. We'll see, what happens in the future. But eventually, tomorrow will not come. And the best thing that we can do to protect our family is to do this planning now while we are healthy. Because if we wait until we're in the hospital, or some people never get this done and they pass away without a plan, it's very often too late. And Olivia, who's monitoring the messages right now, could tell you, she just went and met with a gentleman yesterday in the hospital who's, at the end stages of his life. Fortunately for him, we were able to get out there in time. But that's really not the time that we want to be doing estate planning. Those hospital visits, while we're happy to make them, that is a very stressful time and not the time that we recommend to be doing your estate planning. It is so much better to have that done at the outset. Also, the third reason that people don't change, complex legal issues. There's probate and tax law and trust law, and what is this thing called? The Medicaid, and it's just very confusing. And it turns people away. Or you might go to an attorney that does all of these areas of law, maybe someone in the family. Here at Cheryl David's office, this is all we do. So while I can't tell you that, that real estate attorney who also does divorces and estate plan won't make you a great plan, I can tell you this is, again, all that we do, and it is done so, so well. So what are your concerns? Our clients come to us with a few main concerns. So number 1, they want to pass on their hard-earned wealth without the government or courts being involved. Number 2, to save money. They don't want to pay unnecessary taxes or fees or court costs. These court costs, when people pass away, it is astronomical. And the number 1 misconception that I hear from people that I meet with every day is, I have a will. Why would there be court? And I understand that logic, but in North Carolina, a will is a ticket to court. And while at the first death, if you're married, there may not be much to do unless your spouse had a car or accounts in their own name. At that second death, we really see our big probate. And with that said, sometimes we have spouses that keep everything separate. And for them, there will be 2 probates. So talk about avoiding unnecessary expenses. There are certainly ways that we can plan so that you're not paying more than you have to. The number 3 concern, avoid going broke from nursing home and other crushing medical expenses. So this is really one of my main practice areas here at this office is asset protection. And we work with families, and you may not even know this was an option, but working with families so that if there is a grave illness where somebody has to go to a nursing home, to skilled care, and you'll know when it's skilled care because this is the type of care where it's running 8 to 10, sometimes even more. We've had a client at Kindred on Vent, and it was over $20,000 a month. So you'll know when you're in that situation because you're cutting a big check every month. So what I want everyone on here to know is you do not have to go broke with nursing home care. And you may not have the time to understand how that happens, but the number 1 thing that you can do to protect yourself is keep our firm's phone number, in your contact information. Let your kids know that if anything happens to me, please call Cheryl David's office and I will help you. But in this state, if you are married and I have the right documents in place, I can typically protect everything for a married couple. Or if you're single, we can typically protect 50% as long as you have the correct documents. And that by that, I mean a power of attorney. But not all powers of attorney have the nursing home protection language that I need to be able to save your house. So definitely give us a call if you'd like us to look at your power of attorney to see if you have that language. I'd be happy to do so in that personal consultation. Number 4 concern, how do we protect our minor kids if we're not around? So we're going to show you some simple steps today to protect your children, even if you're not around to do it. And I must admit, I was a little surprised when I did the research for this workshop to find that parents were asked to describe what is the worst thing that could happen to your children. And they mentioned all sorts of diseases or illness or injuries, obstacles in the lives of their young ones. But almost no one mentioned what we believe is the worst thing that could happen to your kids. And if you consider it for a moment, perhaps the most catastrophic event in your child's life would be your premature death. The people that love them the most in the world, embrace their dreams, and who would sacrifice themselves for their benefit are now gone. And who is going to replace you in their lives and bring the same level of love and devotion? And do we really want the state of North Carolina to decide who raises your children and handles their money? And I know from looking at some of the people that attended here, you may not have minor children, but you might have grandchildren who are. So it is just as important as it is for you, maybe more important, to make sure that our children also have their proper estate planning done. And we're happy to meet with everybody. Even though we are an elder law firm, we meet with people of all ages. Once you are 18 years old, you are old enough to have an estate plan. And you better believe on my 18th birthday, my mother dragged me into this office and made me sign my estate plan. And I thought that was so ridiculous at the time. I just wanted to be with my friends, but it really is so important. And the number 5th concern, avoiding family members fighting with each other over money. Your death should really be a time where family is brought closer together. But what we often see, especially with poor estate planning, is this is a time that tears families apart. So what's most valuable to you? What do you want to protect? A lot of our clients tell us it might be their spouse or their kids or their grandchildren. They want to protect their health, charities, friends, business interests. We should have put pets on here. That's a huge passion of mine, is our pets, making sure that they're taken care of if we're not here, and making sure that they're with the person that we would trust them with the most. So I like to use this case example just to, bring this all down to earth a little bit. So I'd like to introduce you to Bill and Mary. They're a North Carolina couple in their 60s and have an estate worth approximately $700,000. And while Bill and Mary are a married couple, I don't want you to think that if you're, not married, that this doesn't apply to you. Estate planning applies to everybody, whether you're married, single, unmarried, or you have a partner, widow, divorced. Maybe you've been married more than once. Estate planning really is for everybody. So Bill and Mary, they have 2 kids. Susan, she is so responsible. She's an accountant. She's married to Jason. We'll talk about Jason in a minute. And they have 2 kids. Susan is the perfect child for them. And then we have John. What can we say about John? He has not gotten his life together yet. He still lives in the basement. He has all these great ideas. They're not really great. And if you give this kid $1, it will be gone so fast. And if, he has people around him who will help relieve him of money. So we want to be really careful when planning for John, knowing that an inheritance could be detrimental to him. So Bill and Mary, they have a lot of things on their to-do list. At the top of that list is exercise. They want to go on some vacations, plan their retirement. They like to volunteer at the church. They're going to prepay their funeral, create a will. The will's at the bottom of the list, which is what we find all the time. And on that number 1, exercise, he does go to the gym. And he hasn't been in a long time. And unfortunately, he has a stroke. Luckily for Bill, he recovers. However, he is now not able to stay in the home and care for himself. And Bill and Mary, they have some options as far as Bill's planning and Mary's planning when it comes to what happens when they pass away. So some of the couples that we talk to, they joke, they're going to spend every last dollar. And you might have seen the bumper sticker, I'm driving my child's inheritance. If you can time your death that perfectly, go for it. If there is nothing in your name when you pass away, there will not be anything to take through the will. And therefore, we won't have a probate. Probate is that process of filing the will at the courthouse. So if you can spend every last dollar, wonderful. I have yet to see that happen. I was talking with someone today, and there's like a $200 check, and they're just going to let it go because it's just not worth the heartache and hassle of going through a probate. You could die intestate. So dying intestate is when you pass away without a will, without a plan. And I mentioned earlier that if you pass away without a plan, North Carolina has a plan for you. And if you're married, it is so important to have a will because not everything goes to your spouse. They'll be entitled to the first $60,000 and then a percentage after that, depending on whether this is your first marriage or consecutive after that, and then how long you've been married. So if it is your intention that everything go to your spouse, we really need to place that in a will. And if you aren't married or you're widowed or have children, it is just so important to have a will in place because eventually the day will come where you're not here and we want to know who's in charge. We don't want to have this fighting. So right now I have a situation where someone's child passed away and she did not have a will and her family members are fighting over who will be the administrator of her estate. So one of the best gifts that we can give our family is making these decisions for them and not putting all that pressure on them. Another option for Bill and Mary when they're doing their estate planning is putting everything in joint tenancy. So with your bank account, you and your spouse are on that, or maybe you and a child, and that's joint tenants. And when you pass away, 95% of the time that account will pass to your child. Or if you're married and you have a child, if you're married and your spouse is on your deed, if you pass away, typically the house passes to them. Sometimes there's exceptions, obviously, but so joint tenancy it's an okay option, but it really only plans for that first death. And eventually the day will come where both of those owners on that account are gone. And we really need to have an estate plan in place to make sure that your wishes are covered. And one thing I will mention about joint tenancy, because a lot of our clients love this option, they'll just put their child on their bank account. But the second that you do that or put your child on your house, that becomes theirs. And whatever problems may be going on in their life, your house is now attached to that, whether it be divorce or creditors, or maybe they just get very sick. So that is not my favorite option. There are much better ways to do it. Creating a simple will. So a lot of our clients do wills, and we'll talk about wills tonight, but it is a great option for people to list out, are any gifts that they'd want to make and who they would like to be in charge and how they want assets divided. Are there pets that we want to place with somebody? Are there charitable gifts that we want to make? The fifth option is creating a bare bones or unfunded trust. So I would say that 9 out of 10 trusts that clients bring into me on a weekly basis are unfunded. And these are trusts that really are not going to work unless you have a trust with everything inside of it. So your bank accounts, your bonds, your stocks, your brokerages, unless everything is inside of this trust. And I like to say the trust is like a piggy bank, and we want everything to be inside of it. But all it takes is one account to be left out of that trust, and your family will be going to court. And why do attorneys create unfunded trusts? It is a lot of work to put all of those accounts in. And here at Cheryl David's office, we truly believe that is our job. And that's why this trust process takes a bit. So people that hire us for a trust, the whole process is about 6 weeks. And we'll help your family for a couple months even after that, because we understand it takes time to get all the accounts into the trust. And this is what I'm talking about, the complete estate plan with a revocable trust, with the key step of making sure that everything is inside that piggy bank. And with the piggy bank, you still have access to it. You can pull the money out. Your money's not in jail. and you can buy houses and sell houses. So I know that's a big concern with trusts. And, some people, they hear trust and they're like, oh, trust fund kids, you have to have, millions and millions of dollars. And really, I typically recommend trusts for clients that have estates that exceed 300,000 or 400,000. Because at the end of the day, we have to look at the probate process and how much is that going to cost and how much time is that going to take. And I typically see that it takes about a year and that people spend about 5% of the estate, whether it be through the court fees, attorney fees, executor fees. So the complete estate plan with the revocable trust is really an excellent option for those families that are wanting to avoid court. But if you have one of those bare bone trusts, and how can we know that you have one? I call it the mailbox rule. So when you get your mail from the financial institutions, are you seeing it in your name? So is it in Bill and Mary Jones's name, or is it in the Bill and Mary Jones trust name? And if you're not seeing that it's in the trust, then it is an account that will have to go through probate when you pass away. So here again, I mentioned that is just something we take so seriously. If you're going to pay the money for a trust, we need to make sure it's going to work. And a lot of these firms around town that do trust that don't put everything in, you're none the wiser, because by the time we find out it doesn't work, you're no longer here. So what we often see with a lot of our clients are these I love you wills. It's a very simple will. Honey, I love you. If I'm not here, everything goes to my spouse. And that's fine for now. Really at the first death, that's okay. But what we typically see is eventually both of you are gone, or maybe one of you gets remarried. So we really just, instead of saying, everything goes to my spouse, we want to go a step further. What happens if your spouse is not here? Because if Mary were to get remarried, if Bill passes away, and we'll find out that she does, and we have something like a simple will that leaves her new husband everything and leaves it to her kids only if he passes away first, you're really taking a pretty big gamble on who's going to outlive who. So if you have these simple wills of, one of you will pass away first. And at that time, we do see people unintentionally disinherit their entire families by leaving assets to a spouse who then leaves assets to their kids instead of necessarily to yours. So just something to think about. And the way to fix that, especially if you are in a blended family, is making sure that both families are mentioned in each of your wills. That way we're not disinheriting anybody. And this is the number one reason that I see people disinherited. Okay, so unfortunately, while after the first stroke, Bill was okay, he does have a second stroke and becomes completely disabled. And in this instance, he did not have an estate plan. So who's going to handle Bill's affairs? Because at this point, he's still alive. He just lacks capacity to be able to handle the finances. And he handled everything for his family. So we're going to be taking our first trip to probate court now for a process called guardianship. And I really hope nobody here has had to go through a guardianship. It's a process that was designed to protect the mentally disabled, but it is an absolute nightmare. And I like to say that guardian should be a last resort. It's humiliating. We often have elderly individuals being wheeled into court. They're not sure what's going on. It's confusing. The court is totally in control. You have to get their permission to do everything. I had a client, because I spent the first few years of my practice handling guardianships. He just simply wanted to buy his father a TV, like a $500 TV for his nursing home room to keep him entertained. And he made the mistake of not petitioning the court. And how many of us here really know how to draft a petition? Well, he didn't petition the court for permission to buy that TV. So you better believe they turned around and said, no way. And he had to hire us to draft that petition for him. And he probably spent more than that TV even cost. So the court is totally in control. It's time consuming. The weeks it takes to even get a guardian appointed. And then every year thereafter, there will be annual accountings. It is totally public. So anybody can kind of go in and check out what's going on. And it's expensive. There's court fees. There are attorney fees, accounting fees, guardian fees. So if you learn nothing else today, please let's avoid guardianship. And the way that we do that is with two documents, a healthcare power of attorney and a financial power of attorney. And these are the documents where we can list an agent who we would want to be in control if we are incapacitated. Maybe someone has a stroke or, anything. We just want to make sure that we have picked that person. And with those two documents, the healthcare power of attorney and a financial power of attorney, we can, under most circumstances, avoid a guardianship, which is beautiful. Now, sometimes it's unavoidable. Someone's being taken advantage of, and we need to restrict someone's ability to be able to check themselves out of, assisted living or memory care, or restrict their ability to sign their names because they've been scammed. So sometimes we have to do it even with a guardianship, but I do not want incapacity alone to be the reason that somebody had to go through court. So after his guardianship is in place and he lives a bit longer, he passes away. And now Mary is taking her second trip to court, and this time for a probate. And this is that process where the will is filed. We give notice to all the interested parties. We have to track down heirs. Olivia and I spoke with a gentleman today. He does not know where his brother is. So, this is part of that probate process, finding that brother. It's a forum to resolve any disputes. All parties have a say. Everybody has to sign off. We pay the creditors. So we do a 90-day notice to creditors after that estate is opened. We do inventories and get assets appraised. Quite often, tax clearance holds these estates open for over a year. So I have estates of people who passed away pretty much this time last year, and their probates are still open because we have to wait for this last tax return, and the documents have not been released by the IRS yet. And you better believe these families, they get, it's very frustrating that these probates last this long. So a year is not uncommon. And that child that you name as your executor, especially if you have multiple children, they're taking the brunt of it. Their siblings don't realize or understand why this is taking so long, and they blame them. So you named your child because they're responsible and they're going to do the right thing, but sometimes this is quite the punishment. And then finally, at the end of this year in court, everything is distributed. So why should we avoid probate if we can? It's expensive, number one. We, again, typically see about 5% loss through that process. The court takes $4 on every 1,000 of probate assets. So this does not include your real estate, but it includes bank accounts or brokerages, anything like that that goes through the probate process. That's capped at $6,000. There's publication and bond fees. We usually use the Jamestown News to post our notice to creditors because it's the cheapest in Guilford County. And then executors and attorneys typically get anywhere from 2 to 5% each. I've already talked about how time consuming it is, and we need, just like the guardianship, permission from the court to sell or distribute property. So just even selling a house, it's just not as simple as you'd like. It's totally public. So anybody who's watching right now could go to the courthouse tomorrow and check out anybody's will. And there's multiple probates, so get ready to travel if you have properties in multiple states. There will be a probate in every state that you have real estate, and that includes timeshares. And I mentioned that Mary's going to get remarried after Bill passes away. So meet Tom. He brings over some nice casserole for Mary after her husband passes away, and she's going to get remarried. And I mentioned these sweetheart wills and how we risk that Susan and John get nothing if she remarries Tom. And Bill's family camp, they could potentially inherit everything from Mary's family, especially if they had one of those sweetheart wills where she says, everything goes to Tom when I pass away. And if I outlive Tom, it goes to my kids. Well, if she passes away first, it all went to him. Nothing is going to her kids unless Tom feels the need to share with them. And sometimes we see people, especially in these blended, families, second and third marriage, they request that we not leave anything to their new spouse. So unfortunately, in North Carolina, we would be required to leave a portion of our estate to Tom, up to half, depending on how long they've been married. And if they're later divorced, a new spouse may receive much of the assets. So one way we can protect against this, if you are already married and freaking out right now that I just said this, you can do something called a postnup. So if it's really your plan that your spouse not inherit anything at your death, then a postnuptial agreement is the way to plan that. And then in your will, we can say everything goes to your kids. So after Bill passes away, Mary has the whole $700,000 estate. And typically a surviving spouse like Mary may live an average of 7 years after her husband passes away. And family assets traditionally double in 10 years' time. And she's fortunate. And let's say in this situation, she does live 10 years after Bill's death. However, she has Alzheimer's, and Mary is placed in a nursing home. And about half of the elderly end up in a nursing home at some point before their death, hopefully for short stays, but we quite often see a lot of people in long-term care, and she's unable to handle her affairs. And the average stay in a nursing home is around 2.4 years, but a typical stay is 5 to 10. And because she did not have proper estate planning, our family is back in court for probate, our third time back in court. And who do we hope or think that the court is going to appoint as guardian? I sure hope that they appoint Susan. But with these guardianship proceedings, oftentimes these hearing officers are only really seeing the family for a very short amount of time, maybe 30 minutes. And John, let's say he cuts his hair and puts on a suit and he talks the talk because he has no job. He can practice that talk all day long. He very well could be appointed. And I've seen John's appointed before. So we just want to be really careful again and have our financial power of attorney and our healthcare power of attorney. So we can say, if we have Alzheimer's, or even if it's not Alzheimer's, incapacity in general, we want Susan as our agent. And then it can stay out of court altogether. I had a case years ago where a woman, she was married to a man. He had his own kids and they were totally estranged. And the husband had dementia. And there was a power of attorney in place, but this is one of those rare instances where there was a really bad child involved who went and had incapacitated dad sign a new one. And we went to guardianship court. And she alleged all sorts of horrible things against this wife. And this husband and wife had been together over 30 years. I mean, they trusted each other. They wanted each other to handle business. And this daughter was really not in the picture. But, you know, for whatever reason, this did have to go to guardianship court. And this daughter, I mean, she put up quite the fight, and they almost believed everything that she was saying, alleging that this man's spouse was beating him because he had bruises. Well, the man had been falling. At the end of the day, they determined that there was no issues with this wife being her husband's power of attorney or guardian. And the daughter was not the best option. Again, they hadn't seen each other in 30 years, but having proper estate planning, like had this family had a trust, we really could have avoided court. Or had they had a better power of attorney, a stronger power of attorney, you know, we really maybe could have avoided that process. And the point that I'm trying to make here is because the court's only seeing you for such a short amount of time, they may appoint somebody who you would not want, like this estranged daughter, to handle your affairs. Mary passes away, and now we are back in court for the fourth time, and hopefully our last time for probate. And this not having a plan, it turned out to be a really expensive plan. So let's say their estate had grown to $1.4 million by the time Mary passed away. She had spent about $420,000 on her 5-year nursing home stay. Probate was about 5% lost through that process to guardianship. At the end of the day, they lost just a lot of money. And now each child is going to be distributed $458,000. And are they ready for that? So I'd like you to meet Jason. This is Susan's lazy husband. He doesn't work. He stays at home and just drinks all day. Unfortunately, because Susan's married to him and she inherits this money and commingles it into the house that she owns with Jason and puts it into their joint bank account, when they get divorced, he's going to get half. So what I'm going to be talking to you guys about, and I'll just go ahead and talk about it now, with a trust, and the trust specifically that our office does, we actually write divorce protection in there so that when your child inherits money, if the marriage does not work out, that money is protected. It is also protected from lawsuits, from creditors, but this divorce one's a big one for our clients. And while it's not protected if you get sued, it is protected if your kids get sued or get sick. And what about John? So he, again, is a walking liability factory. I'm sure he'll get in an accident. I doubt he'll pay taxes on the money. He doesn't pay his bills. And we really risk losing all of this inheritance because if we do not have a special plan for John, he inherits everything and it's up to him how he spends it. And I mentioned earlier, there are loads of people out there that are ready to relieve him of that money. So the summary of an ineffective plan, in this case, we didn't have any guardianship protection. We didn't have any probate protection, no nursing home protection. We didn't have remarriage protection when Mary marries Tom. No protection if our child gets divorced, if our child has creditors, or maybe they have a drug addiction. No way to preserve the family's life values and stories. So there must be a better way. And of course, that's what you're here to hear today. So there is. Making sure that we are doing planning so that our hard-earned assets go to who we want, when we want. So John, not right now, that they're handled by the person that we want, that Susan is in charge. And there's no question. And while John may want to be in charge, and I'm sure he does, at the end of the day, he just doesn't have that decision. You made that decision. Protecting the people that we want. And at least the cost we can avoid or minimize guardianship with these correct documents. We really don't have to go through a guardianship. We can completely avoid probate. In their case, Bill and Mary, there were 2 probates because they had assets that were in individual names. So we can make it so there's not even 1 probate. Avoiding estate taxes if that's an issue for you. For a lot of us, taxes aren't a big concern. It's in the millions right now. Long-term care costs and then fighting between the kids, whether that be in court or just family infighting. So what is a revocable trust? It is a contract. And just like you have contracts with the painter or the plumber that don't go through court, this is a contract that does not go through court. And a trust is a lot like a will in that we're going to put our gifts, the gifts that we want to occur, how we want everything divided, who we want in charge. But it's a will in contract form that will not go through court when you pass away. And I'm going to talk a lot about trusts, but I'm not here to knock wills. I would much rather my clients have a will than nothing. And quite often, I'd say half of our clients do a trust and half do wills. And for you at tonight's webinar, the decision is really, or the goal is to make a decision on which of these plans makes the most sense to you. So how does a revocable trust work? It is all about how assets are titled. So I mentioned the piggy bank earlier. Goodness, this just happened to be in the room, so I'm using it all the time. This piggy bank, we want everything to be in it if this piggy bank is our trust. So our brokerage accounts, our cash, our stocks, our gold, everything needs to be in this trust. And if one thing is outside of this trust, that is going through court. And I mentioned earlier, a lot of attorneys do trusts, but they don't put everything in. And I have 2 guesses why that is. One, I mentioned earlier, it's just a whole lot of work. We have an entire meeting dedicated to assets. So if you decide that you'd like to retain us for a trust, you'll have an asset meeting with our wonderful paralegal, Claudia, and she's going to go through everything you have. And mostly everything will be tied to this trust one way or another. Because again, all it takes is one account left out of that trust and we're going through court. So joint property goes in the trusts. First spouse's property, second spouse's property. We can divide things out if you do keep things in separate names. We can still do that. Even within a joint trust, we can keep assets separated. Most of our clients, it's joint property and that can go in the trust, but we put your house in the trust, Everything goes in this trust, especially if you have real estate or timeshares in other states. We will hire attorneys from those states, and that's our job. We'll find them and get those properties into the trust so that you're not having to go through a probate in Florida or in South Carolina, or, we have family farmland in Virginia, making sure everything is titled in that trust. I forgot to mention my second reason why do attorneys do trust but don't put everything in it? It might be that they're hoping that your family comes back to them for the probate. So a lot of times what I see is the attorney simply hires whoever's name is on that will, whatever attorney did it. And so that's a huge business. Probate is a huge business. So I'm going to go through some titles that you might need to remember. So when a trust is in place, we hear the word trustor. So this is simply the person who's creating the trust, whose assets are getting transferred into the trust. So if you're married, you and your husband are the trustor. Who are the trustees? This is the person who's managing the trust assets. So while you're alive, this is you. You are the trustee. And the beneficiaries. While you're alive, you're the beneficiary. So while you're alive, you're really not going to see a huge difference day to day, except I mentioned earlier that mail that's coming in for the mailbox rule. You'll see that a lot of assets are in the trust name, but you still have full control. When you pass away, that's when we will have our beneficiaries, like the kids, or it might be family members or friends or charities. So in this instance, Bill and Mary occupy all three positions. They are both the trustors, the trustees, and the beneficiaries. And really, I mentioned it's business as usual. They are totally in control. They can amend or revoke the trust if they need to. They can still buy, sell, trade assets, refinance the house. There's no new tax forms. So with these revocable trusts that follows your social security number, it really is you, and there's no change in how you file taxes. No change in the property tax bills. The trust is a lot like a joint bank account, but it's more powerful because it is protecting us if we're incapacitated and protecting us if we pass away. And you really can put, I won't say anything, it says anything, but most assets into the trust and take it out. What do we not put in the trust? Assets like IRAs or 401ks don't go in the trust. However, I do name the trust as the beneficiary after your spouse if you're married, or if you're not married, or your spouse has passed away, the trust is the primary beneficiary. And I want to touch on that for a second. So IRAs and 401ks, things with beneficiaries, they don't typically go through court, though in the last week I've seen some because there were no beneficiaries on it, and those do go through court. So check those, please. But when somebody inherits money from an IRA or 401k, that money is just really thrust upon the family members or friends or whoever is inheriting. And there's no divorce protection or creditor protection for that. So with the trust, if I name the trust as the beneficiary, it still gets to the kids, but it gets to them with that nursing home protection and creditor protection and divorce protection. And also, what if your child passes away? Maybe you have minor grandchildren or just grandchildren who aren't ready to control money. So if I name the trust as the beneficiary, it's just wrapped up and protected more than if we name a child outright. So although IRAs and 401ks, we're going to avoid court anyways, the trust is still a really nice option. So why create a living trust? Again, while you're alive, it's business as usual. And this is really a standby device so that when you pass away, the family is protected. Because this trust, when you die, will not die. And it does not have to go through probate because it did not die. It is protection if you become disabled. We can avoid having to go through court, and it protects your spouse, your children, your grandchildren, the pets. So let's give Bill and Mary a do-over. This time they have a complete estate plan with the trust, the powers of attorney, advance directives. This is going to cover a lot of their options. So on their new to-do list, creating that estate plan was at the top, whereas before it was on the bottom. So let's start from the beginning. Bill has a stroke, but this time there's no guardianship. The estate plan had special instructions for exactly what happened upon disability. So we're not going through that process where we're, going through this very public procedure. There's no loss of control. We're not taking weeks, months, years out of our lives, dealing with all of that's involved with a probate through guardianship, and avoiding those court fees, attorney's fees, and not having to do those annual accountings. So when Bill does ultimately pass away, will his estate need to go into probate? Nope. There's no need for probate because all of the assets were titled in the trust, and Bill's death really has no impact as far as those assets are concerned. So we've avoided court. We've avoided the fees associated with court, the executor fees and attorney's fees, that year that people are stuck in court. No way. And I talked with the family this morning and they were like, oh, we're wealthy. We can just do the will. We can pay for that. I don't totally understand that, but that's okay. So, for those of you that still want to do the will, that's fine. But I didn't quite understand that conversation because these two kids that I spoke with, they have their own lives. They don't live in this state. They may have money, but why would you pay 5% of your estate if you don't have to, just because you have money? And even more importantly than the money, the time that it takes. So I did not totally understand that situation, but for a lot of our clients, the trust makes sense because, money aside, look how long this takes. So whether or not your kid, you might have the brightest child in the world and have all the money in the world to pay for these court fees, but what about the time that this takes? Let's give them back that time so that they can be with their family, not having to take off work to go through court for a year. We don't have to do any notice to the heirs or the parties, not having to prove the will in the courthouse, no public notice to creditors. It's not public. I met with somebody yesterday and she's terrified of this public notice to creditors because people will now know that this person's house is empty. So there's just so many reasons to avoid probate. And again, if you have properties in multiple states, with a trust, we're able to avoid those probates. So you're not even going through one, let alone multiple. And I did want to talk about death taxes for a bit. So I'll start with North Carolina. We do not have an inheritance tax. That was abolished. So that's good news. And then the federal estate tax, this just increased. So these are brand new numbers I've updated tonight. There will only be a state tax on estates more than 12.92 million. And if you're married and you elect something called portability at the first death, and we would need to know within a certain amount of time to be able to do that, we can actually double it to over $25 million. So the good news for probably everybody on this webinar tonight, we don't have to worry about estate taxes. I do want to mention, though, that this exemption is set to revert to the prior exemption amount of $5 million in 2026. It will be adjusted for inflation. We don't totally know yet what Congress may or may not do, but it is definitely something just to keep an eye out. And I would say once we get closer to that year, if you are over that amount, let's have a conversation. So this time Mary gets Alzheimer's, but we're not having to go through a guardianship. Everything is set up. So we're not paying that money. We're not spending that time. We're not at the court's mercy. And Mary passes away, and I think you know where I'm going, but there will not be a probate. Susan is the trustee when Mary passes away. We're not going through court, and all those things that we avoided for Bill, we're avoiding for Mary as well. And I like to say a trust is a lot like a tube of toothpaste, although I should tonight say it's like a piggy bank. But once assets are in the tube, they are protected. And outright distributions of assets, like giving your IRA directly to the children or giving your bank account directly to the child because they were joint on it with you, it's a lot like that toothpaste being out of the bottle. Once it's out, it is not protected. It's not clean anymore. And it's very hard to ever get that back in. So with this trust, your estate is very much protected and kept clean. And the assets are protected for the kids with a trust. So we can set up special accounts. So for Susan, we can put divorce protection in there so that Jason gets nothing when you pass away and they ultimately get divorced. And for John, we can actually do something called a century trust or a spendthrift trust. And we do these very often. There is no judgments here. I don't want anyone to be afraid of telling us what's going on in their family. As your attorney, we have confidentiality, and this is all very private. So with John, we can put all of his assets into this family protection trust, spendthrift trust, and it's protected. If he's divorced, if he's sued, if there's creditors, it's protecting John from himself. So we definitely want to keep John's assets in the tube, protected, and direct the trustee how to squeeze out those assets. So as he needs money, Susan can spend that for him, but he does not have control. And if it's set up properly and the money's in the trust, it can't be attached to by John's creditors. And statute of limitations and judgments can expire. And we just want to make sure that, again, everything is protected. The trust could own a house. It can pay John's bills. It can even give him a monthly allowance. And for those of you that may have special needs children or know of people that do, it's really important to make sure that we have special language in place to protect them, especially if they're on Medicaid or could be one day. We don't want to do anything that could possibly interfere with your child's benefits. So if special needs are in your family, let's have a conversation about that. We could actually leave your child money, but protect it so that they can get benefits and have this money for them. So we've protected a lot with this revocable trust for all the issues, the guardianship, probate for both of them. Mary gets remarried, but we have remarriage protection that you can opt to have within this trust. And Bill and Mary did. So when Mary got married, oh gosh, I need to change her name because it's Mary. When Mary gets remarried to Tom, we have special divorce, remarriage triggers that we can state inside of your documents if your spouse were to get remarried when you pass away. Nursing home costs, I do want to talk about this for a moment. There is a special power of attorney, and whether you do a will or trust package with our office, this special power of attorney is included. This is the document that lets me protect your house and your money if you get sick. And not all powers of attorney have that language. And I want you to hear that because I have so many meetings with people and they're like, oh, I already have it. Not all powers of attorney have nursing home protection. So please let me look at it. I'll be totally honest if it does. But there was a law change in 2018. So a lot of powers of attorney are now out of date. And even some of the new ones that I've seen in 2018, like the statutory powers of attorney you can get online for free, do not have nursing home protection. So we really want to make sure that that's in your arsenal because I can protect so much if you get sick, but I have to have that special language. So our clients, when they're doing a package of a trust or a will, they're getting that power of attorney. And then they know to get in touch with me down the road and we can protect assets when needed. But for now, most of our clients, we don't protect anything until they call us at that time. We have avoided Mary's probate. Estate taxes weren't a concern here. And then Susan's divorce and John's lawsuit. And the kids really have pretty immediate access to assets when you pass away. They just need to wait on those death certificates and then they can get into the accounts. So Susan will be totally in control. She can immediately distribute property as needed, but according to the wishes of her parents. She does not get to make her own decisions on how things are divided. But the beauty is she does not now have to wait for the court. And she can choose to hire professionals to help her. But if she does so, it's not going to be subject to court oversight this time. And a lot of times with the trust, I liken it to kitchen table law. This is something that your kids very much can do on their own. If they just don't want to, though, we have a department that can help with that. So I want to talk a bit about long-term care Medicaid planning. So what happens if you get disabled and need long-term care? There are some ways to plan ahead to protect your assets. So 5 ways that we typically see: using your own money to pay for that care. Not my favorite option, just because this is how we see families go broke. And it's expensive at $10,000 a month is what I usually see. You can buy long-term care insurance, and it's a really great option if you can afford it. And I know the premiums on that, if you already have it, are expensive, but we see it's night and day between the people that don't have that and do. For my veterans who are on here right now, there's a benefit called aid in attendance. you have to be sick, so I hope no one here needs that right now, but for certain qualifying veterans, I believe you had to have served for at least 90 days, and at least one of those days needed to be during wartime, even if you were not boots on the ground. And there are certain asset and income limits, but definitely talk to your VA officer if there is an illness to see if you're eligible. It entitles a disabled veteran typically around $2,100 a month, and your widow actually $1,100 a month if eligible again. And a lot of people are eligible for this and just simply do not know it exists. So this is a huge one just to let people know about. There's Medicare. And a lot of people confuse Medicare and then there's something called Medicaid. So a lot of people confuse those. Medicare it's health insurance. If you get sick and need a nursing home stay, typically it will cover rehab, usually for anywhere from 20 to 100 days. Usually it shuts off at 20 days as soon as the doctors say there's no improvement. But it does not, under any circumstance, last forever. And that's a huge misconception. So for people that need to go to the nursing home and stay, Medicaid is really what I like to go for. And I hate even using the word Medicaid because people say, oh, you just have to be like a pauper and totally impoverished. And the truth of the matter is, we have a whole department here that protects assets for families when people are in that situation to access Medicaid for your family without going broke. So, just because you've heard bad things about Medicaid, it really is such a phenomenal tool that we can use. We do everything on the up and up. It's all legal. When we go to apply for Medicaid, we're not hiding money, absolutely not hiding it. I tell the caseworkers exactly where everything went. And because I did this, this, and this, that money's protected and they get it. Of course, they're not in the business that they're going to tell you to go find an elder law attorney, but I just want you to all know there are ways to protect money if you get sick, but I really need to make sure that you have that power of attorney that I was talking about, because if you come in at that time or the kids come in and it has a power of attorney, but does not have those special language I need, I can't protect anything. And you may have heard, but Blair, I've heard you can get Medicaid and keep your house. Well, that's true. However, when you pass away and the house goes to sell when you're gone, North Carolina has a lien on it and they'll take the house up to what they paid into your Medicaid, which is usually everything. So there are special deeds that we can do to protect your house without a 5-year look back. And if you don't know what that means, just know I can protect your house instantly, immediately, without any delay. But if we don't do that until there's an incapacitating event, I really have to have that power of attorney to do it. And simply just putting your kids on the bank account or selling your house for $1, it's just not enough. Selling the house for $1 is going to cause a huge penalty and you won't get benefits. You'll actually get punished. And then putting children on accounts, while it may keep things out of probate, it does not protect from nursing homes. They can still attach to that because they have this rule where they follow the money and see who's the person that put the money in. That's whose money it is. So Medicaid, I won't go into too much detail, but just know that there are ways for us to protect assets. Medicaid myth number one, you have to give all your assets away or spend them all down on your health costs. Absolutely not. And some people, they'll go ahead and give assets away now because they've heard, after 60 months, it won't get taken. Okay, sure, but we still need you to have money to live off of. And what I'm telling you now is that if you are married and I have the right documents in place, I can protect everything without a 5-year look back. So keep your money. You need that to live off of. And I don't want you to just give it away. What if your child passes away or gets sick themselves? That money is lost and we really needed that for you. And plus, how often can we really time 60 months? I've seen so many people give assets away and then they get sick in 2 years. So there really, really is a better way. I'm happy to talk with you about that. I spend half of my day dealing with Medicaid cases. Medicaid myth, I mentioned earlier, a lot of people think they can take your home, and they can take your home, but there's a special deed that we do to protect the home so that it does not get taken. It is immediately protected. And for a lot of people, that's their biggest asset. So come talk to us. We'll have a conversation. Now, we do offer it's called a Medicaid trust. So for some of our clients, especially if there is over a few $100,000 and there's money that is not in IRAs that they can afford to live without, we will go ahead and put that into an irrevocable trust. But unlike the revocable trust that I've been talking to you about earlier, and the revocable trust is the one you have full access to, that does not have nursing home protection. So with the revocable trust, you can pull the money out, you can put it in, but do know that those don't have nursing home protection in it. There's a different type of trust, the irrevocable trust, where you can't access the money. So that's like a piggy bank with no plug. With the irrevocable trust, after 5 years, that money is protected. So to be quite honest, for most of our clients, we don't know if we have 5 years. By the time we're having that conversation, we don't. So I just want to make sure that those clients have the power of attorney at a minimum. But sometimes we have people reach out to us with a very slow progressing illness, and we will go ahead and put assets into an irrevocable trust to go ahead and start what's called that 5-year look back. And after 5 years, it's protected. So I'm getting towards the end, and I'm sorry I went over. Remember, knowledge is not enough. We really need an action plan. So tonight, you have the knowledge. And I know I mentioned earlier, a reason that people don't plan is lack of knowledge. So you hopefully have that now. What we really need is to make this happen. Again, what do you need to do to make this happen? Maybe it's just starting with that personal consultation. We can do it over Zoom. We can do it over the phone. We can do it in person. We're here to make you comfortable. Most people do them over the phone, but if you want to come in, we're happy to see you. And when should you get started? So we will offer a personal consultation with one of the attorneys over the next 2 weeks. If you are too busy over the next couple of weeks and need to come in later, that's fine, but there will be a consult fee of $350. So if we can get you in within the next 2 weeks, there's no charge. If you already have estate plans, because I do see quite a bit of clients, so hello, I'm happy to review those with you, make sure any law changes have been addressed. And what's the investment to get it done right? So what to expect working with us. So we're helping you with a will. That process typically takes around 3 weeks. So to start, we'll have that conversation, whether it be on the phone or in person. We'll go through your family situation and finances. And then if you decide to hire us for a will, you'll come to sign after about 3 weeks. With a trust, the process is a bit longer. It's about 6 weeks. And part of the reason that it takes so much longer is we have that asset appointment. So we write letters to all of your financial institutions telling them, what do they need to do with your stocks? What do they need to do with your checking account? So the trust just takes a bit longer. So at our firm, we have a philosophy about working with our clients. Because estate planning is an extraordinarily complex area of law, we make it our business to maintain the highest level of expertise required to handle your estate, like we've discussed today in these scenarios. But when it comes to getting advice, there's a lot of it out there, and some of it's good and some of it's bad. And it's probably no surprise that you can get some information about estate planning from a lot of sources like financial planners or accountants or CPAs or brokers, or my favorite, the internet, and probably even from friends who are doing some planning for themselves. And although these folks may have expertise that covers one piece of the picture, they don't typically have an integrated, inclusive knowledge of what it takes to offer complete professional estate planning counsel. And the risky part, which could end up costing you a lot of money, is that they could be lacking the knowledge to handle the matters that are most critical to your estate and to your heirs. And we believe that the success of our law firm rests on one of these 5 core elements. So number 1, our passion for helping families plan, our strong comprehensive knowledge of estate planning issues, our experienced, wonderful staff, our ongoing relationship with your family. So with us, it's not just one and done. We have our newsletters and we like to keep in touch. We'll let you know if there's law changes, but we request that you let us know if there's changes with your family. And a free consultation, so you know exactly what the plan is before you retain us. So our mission and our passion is legacy wealth planning, and it's to make a difference just one family at a time. And all we do is estate, Medicaid, and elder law planning. We will have a customized estate plan that's designed just for you and your family. And we have set fees, so there's no surprises. So after the signing, we allow 2 months for you to make changes if need be. It just takes the pressure off. And to help you choose the best estate plan for your goals, we'll go through any issues or questions that you may have in that complimentary meeting. We'll talk about your family and finances. So here's the funny before the money. So we like to avoid bargains when it comes to parachutes, brain surgery, fire extinguishers, but also estate planning. So our trust, our revocable trust portfolio includes the trust. It also includes everything that you would find in a will package. So pour over wills. And the reason that we give all of our clients backup wills is just in case over the years, something is left out of the trust. So our job at the beginning is to get everything inside the trust, but it happens. So you will have a backup will that says everything goes in there. That power of attorney with nursing home protection, advanced directives, so healthcare powers of attorney and living wills and HIPAA authorizations. A lot of you probably have updated documents since 2008, but if you have one of these really old plans from prior to 2008, there have been a law change with all of those healthcare documents. So our trust portfolio is $6,100. That does include one deed to your home. If there are additional deeds, we'll give you a quote and we can help you hire attorneys in other states. Nursing home protection is an additional amount, but for most of our clients, that power of attorney with the nursing home protection language, that's a good enough start. And also, fully funding your trust to make sure that everything you have is inside that trust. And if you get forms after the trust is signed, we're here to help you fill those out. And usually we will do one joint trust because most of our couples or most of our clients that are married, they have all their assets joint. If you are one of those people that really just keeps everything separate, we would just double this if you each want your own trust, but we can even put separate assets into a trust and still keep that separation if you'd like. Our will portfolio is $2,100 each person. That includes the will. If you have a minor child, that language is included. If you have special needs relatives, that language is included, especially for special needs families. That's a huge job. So we don't believe in charging extra for that with our will. That power of attorney, again, will have that nursing home protection, the advanced directives, the living will, where you can say, don't keep me alive on machines, and the healthcare power of attorney and the HIPAA authorization so that your loved one can sign that patient authorization so that we can get your medical records released so that your insurance will pay the bills. And then something called an estate planning letter, where you can just throughout the years, write out any gifts that you'd like to leave to people so that you're not always having to constantly come back, if you get little items that you want to leave to people. So that will fee is per person, whereas the trust fee is per family. So as long as you and your spouse are planning together, or if you're single, it's going to be $6,100. So you do not have to double this if you're married, unless we are doing two totally separate trusts. And then this one, if we're doing a married couples trust, it would be $4,200. And if we need to piecemeal things, like maybe you have a good will, but we just need to do a power of attorney, we can certainly have that conversation. That power of attorney, for a lot of people, that's all we do, because that is just the thing that's keeping them up at night. That document's $475, but if we do the will or trust package, it's included. So as the famous Pablo Picasso stated, only put off until tomorrow what you are willing to die having left undone. And that's very important. And whether or not you work with us, please make sure that you have some estate plan done to protect your family, because I've just seen the consequences of not having this. So don't put your head in the sand. You've all earned a free initial consultation with the attorney. Olivia has been posting that link throughout. You may also have a free initial consultation with our financial advisors, Wisdom Wealth Care. And we are not trying to take anybody away from their current financial planner if you're happy. We just also offer this service if you don't have somebody. You can set up an appointment on that Calendly link that Olivia's posted, or if you want to put your number in the chat, she can make a note and we'll call you tomorrow. But unless you schedule tonight, we're pretty much going to call everybody tomorrow as well. We do have conditions for that meeting, so we do ask that the appointment be made within 2 weeks. As I mentioned earlier, all decision makers should be present. So if you're married, both spouses should attend. And at that meeting, we will ask you a question. Should we work together? Yes or no? So we just ask that you be ready to make that decision. A no is fine. However, don't feel like you need to make an appointment just to make us happy. You know, if you are going to go somewhere else, or you're not ready to do estate planning, or you wanted to talk about your car accident, you know, we don't need to chat about that, but we would love to see you if you're interested in starting. So again, if you're not serious about moving forward with estate planning, it's okay. We can part ways as friends, and, you know, keep us in mind if you ever need anything. Again, we only do estate planning, elder law, and death administration. So if it's something unrelated to that, you know, issues with your insurance company, we don't handle that. So I hope this was helpful. Olivia, do we have any questions? And you can feel free to sign off if you'd like, or if you'd like to, we're going to hang around for a few minutes and go through some questions. Okay, so I see a couple. If you put a POD on a bank account, does that go through probate? So good question. A POD, that stands for pay on death. Usually pay on death accounts do not go through probate. So for our clients that have wills, I very often am recommending that we do POD accounts. However, depending on the size of your estate, the trust is still a really good option, because on some accounts or assets, we can't do that. Like your house, we can't put a POD on a house. Or occasionally I'll see the POD beneficiary has passed away before you or at the same time. So PODs are a great option, but for some people, you know, the trust still makes a little more sense.
Blair, I got my microphone working. If you would like me to read the next one.
Yeah, please.
Okay, so the next one is, if an account is left out of the trust, does everything go to probate, or is that just that account?
Oh, good question. So that account will be the only thing that we have to pay probate fees on, but a full probate, depending on how much that account was, still has to be done. But no, assets in the trust will not have to go through probate, but a full probate will still likely need to be done. And with that said, with a probate, they don't make it easy at all. And if you're married and you have joint accounts, or you're not married and you just have a child on your account, they still require that we disclose and get date of death statements for those. So even though it might just be one account going through probate, they still require that we disclose joint accounts. And I'm working with a client right now where it really is just one account, but we're having to get just loads of other account information simply because not everything was in the trust. Great question.
All right, so the next one is, if an IRA or 401k goes into a trust upon death, what are the tax ramifications when withdrawn from the trust by the surviving spouse or children?
Another good question. So if you are married, we, for tax purposes, will name your spouse as the primary beneficiary. The trust will be the contingent, only if your spouse is not alive. And we do that because the tax ramifications are less if we name your spouse outright. Now, our trusts do have language that allow us to put 401ks and IRA beneficiaries as the trust. And we kind of assess what's going on when you pass away, because the trust rate is higher. If there's no issues with divorce or with creditors, the kids might take it out. Now with the new Secure Act language that was implemented, and I believe in 2020, it does have to be taken out within 10 years. But I like to assess what's going on at death because people may have passed away and we might have minors involved. So, taxes are definitely something to think about. And then I do see it one last thing. My husband was honorably, let me check. Let me make sure this is something we can answer. Okay, so we have someone who was asking about the widow's benefit. I don't typically handle VA issues. I know with aid and attendance, there just have to be some medical issues in place. Maybe that is somebody's coming in to help you with tasks. Maybe someone's in assisted living. I would certainly check with the VA, but if you are a widow and there are no health concerns, I don't believe that you'll be eligible, but it's certainly worth asking in case they've changed their rules. I just don't have the VA certifications to be able to answer that.
Okay, next one is,
And somebody wrote, if it helps, my mom had aid in attendance, contact the VA downtown. Yeah, the VA, there's some helpful people out there, but it is a really great benefit and just not enough people know about it. Our life insurance benefits part of the estate. So sometimes they pass outside of the estate if we have a beneficiary. So, but as we've seen with a couple of clients, sometimes the beneficiary passes away before you, or sometimes there's not one, but life insurance will pass outside of the estate. With that said, I do like to name the trust as the beneficiary of life insurance, just to get that divorce and creditor protection for our kids. And then someone asked, can you confirm that all assets can be protected in case one spouse needs nursing home care? So to the person that wrote that, let's definitely talk. We would need to have that power of attorney, because if I don't have the right permission slips in place, I cannot protect assets. However, if you did have that power of attorney and your spouse needed skilled nursing home care, I can usually protect everything. If we don't do any sort of planning, North Carolina lets a spouse keep half up to $120,000, but up to $120,000. But if you work with an elder law attorney, we can protect much, much more. Sometimes the only thing that's lost is we have to pay some taxes if we liquidate accounts. So, I can't protect if we have to liquidate the taxes, but yeah, usually we can protect just about everything if there's a healthy spouse at home who lives. And if you're not married, I can usually protect the real estate plus about half of the cash. So the key thing, and we're getting a lot of questions on this one, is making sure that we have that power of attorney. There's a special deed that I can do on your house, and we can certainly talk about that if you bring it up at your meeting, but I can protect your house immediately, even if there's a mortgage on it. Speaking of which, someone said, if there's a mortgage, is your home considered an asset? Yes, because there's still some equity in that house, most likely. So that is something that does typically have to go through court. So I think we got all the questions. Thank you so much. I've never gotten so many good questions before. It shows that you guys were really listening. So I hope to see you in the next couple of weeks at these personal consultations. And thank you so much for joining us tonight. And I'm sorry I went so over, but
Blair, just
yes.
for anybody who didn't get it, I'm going to post that link one more time.
Okay. Thank you, Olivia. All right. I hope everybody has a good night. You're welcome. To the person that said thank you. Oh, you're welcome.